Hi. Hi. Hi.
Good afternoon, Mr. Fortune. Please kindly confirm you can hear me.
Yeah, good afternoon. I can hear you.
All right, thank you. You're welcome. Good afternoon, Mrs. Ihimweme. Please kindly confirm.
Hi, good afternoon. I can hear you.
Good afternoon. Please, I would like you to turn on your videos and I would like to confirm if you're alone where you are. Good afternoon. I can see Benedicta Obiazi. Kindly confirm that you can hear me, please. You're muted. You need to unmute your mic. Mr. Fortune, I cannot see you yet. Okay. Mr. Fortune, can you turn your camera around? I need to confirm that you're alone.
Absolutely.
I can hear you, please.
All right, welcome. Okay, that's fine, Mr. Fortune. Mrs. Ehiweme, kindly turn your camera. Thank you. All right, thank you. Uh, um, Benedicta Obiazi, I hope it's okay to address you that way.
Yes, you may go ahead and press the search.
All right, thank you. I cannot see you. The video is blank. And I noticed there's someone else in your car.
Okay.
All right, you need to turn on your video too. All right. Mr. Fortune, I hope you have your Bible with you. I'll assume you're a Christian. You're muted. You're muted, Mr. Fortune.
Okay. I do not have one physically available right now.
You cannot get, is it possible to get one at all?
Um, can I
My lord, what? You do not have anyone present with you. You can't get anyone.
can I step out for a few moments to see if I can find one?
How long do you need, Mr. Fortune?
Uh, Around 5 minutes max or less. I just need to ask to see if there's any.
All right, 5 minutes, please, Mr. Fortune. Thank you.
Sure.
So we'll just wait for my lord to be ready. Thank you. All right, Mr. Fortune, are you able to get one?
Yes, I found one.
All right, that's great. So I'll on your videos, Benedicta Obiazi, I'll need to turn on your video too. Um, Mr. Fortune, shortly we'll be taking an oath. I'll be sharing to follow the trial. I'll direct you on what to do. You read the first part and the other part will be read to you. Do you understand that, Mr. Fortune?
Sure. Yes.
All right, that's fine. All right, my lord, we're ready.
Right. Who's called the case?
ACO 7424 Mrs. Eyiwe Obasi. Mr. Fortune Obasi. My lord, they are present virtually.
Right. Petitioner, where's your location?
My location is currently in the Netherlands.
Respondent, where is your location?
My location is currently Canada.
Right. Can I have representation?
Free. All right, so for watching my own work, that's for the question.
I didn't quite hear that.
Be published or light on Ogunjimi, my own view appearances for the petitioner, my lord,
Olaito Ogujimi.
as opposites.
With proper respect to the Honorable Court, I am D.O. Ogogon.
Can I have the name again?
D.O. intro.
Can I have the name again? The initials?
D.O. O for boy. O for orange.
E-O.
D.O. D for boy.
B for ball.
Yes, my lord.
The surname?
Ogogono, I'll spell it. O-B-O. B-O-L-O. O-B-O-B-L-O.
O-B-O or O-G-O?
O-B for boy, please. O-B-O.
O-B-O-B-O.
As a composite. O-B-O-B-O-L.
L what?
L-O. The Lord, I appear for the respondents. I'm grateful.
Now, where there is someone appearing from a vehicle, I don't want to see anyone in a vehicle while proceedings is on. If you can't find a corner then to sit, then you may need to log out. You can't be in your car and be in the court. Who is Benedicta Obaze in a vehicle? Very well, my lord. I'll get someplace and then rejoin the meeting. Thank you, my lord. Can't watch proceedings from the car. You must find it so that you don't distract the court. Mr. Adejumo,
Yes, my lord.
please take that person off. Right. Yes.
My lord, the matter is for continuation of trial.
Right.
The respondent wants to give evidence, my lord, for court.
Respondent's case.
Yes, my lord.
My lord, we're prepared to proceed.
Registrar.
My lord.
Yes, so Mr. Fortune, you need to unmute yourself. You would read the first paragraph, you insert your name where required. Go ahead, Mr. Fortune.
Okay.
Can you hear me? Yeah, go ahead.
Okay. I, Fortune Maris Obiazi, swear on the Holy Bible that the evidence that I shall give before this court shall be the truth and the whole truth, and nothing but the truth. So help me God.
All right, Mr. Fortune, just hold on while the other part is read to you.
Mr. Obasi. Mr. Fortune Obasi, can you hear me?
I can hear you.
You are hereby cautioned that if you tell a lie in your testimony in these proceedings or willfully mislead this cause, you are liable to be prosecuted. And if found guilty, you'll be seriously dealt with according to law. Did you understand that? Did
I
you
understand.
understand?
Yes, I do.
I love the witness sworn on the Holy Bible.
Right.
Fortune, good morning.
Good morning.
I will be putting questions to you and you giving evidence. Take it easy. Do not be too far because the Lord is recording the law. Be audible, be clear, so the court can hear you. Is that okay?
Okay.
All right. Please tell the court your name.
1 minute,
Okay.
please. So your answer was filed when? Okay. Learned counsel. The answer you are relying on, is that the one of the 21st of March?
Yes, that's correct, 21st of March.
Right. Right.
So just tell the court your name.
My name is Fortune Marius Obiazi.
Fortune.
Marius Obiazi.
Right.
Tell the court your address.
My current address is 3509 James Mowat Trail.
James what?
James Mowat. Mowat spelled as MO
Yes.
WA double T.
MO.
WA
Yes.
double T. Yeah. Yeah. So 3509 James Mowat Place, Southwest. Edmonton, Alberta, Canada.
Right.
Yeah.
Postcode? Does it have a postcode?
Yes, it does have a postal code, my lord. Postal code T5H3G9.
Right.
Your occupation.
I am self-employed in business.
Yes.
Yes. When and where you get married to the petitioner?
Okay. I got married to the petitioner on the 19th December 2020 at St. Patrick's Catholic Church, Asaba, Delta State.
Right.
Marriage produce any children? Did the marriage
No,
produce
there was
children?
there's no children. There was no children produced.
Right.
After your marriage, where did you and the petitioner reside together?
After the marriage, we resided at number 6, Remilade, Okpadokun Street in Ilasan, Lekki, Lagos State.
Remilade.
Remilade Okpadokun, Okpadokun spelled at Opadukun, I believe.
We reside at number 6, Remilade, what?
Okpadokun Street.
Right. Yes.
Do you recall for how long?
Immediately after the marriage, we got that place as a temporary measure. So I want to say around a year.
Right.
Please tell the court the arrangement you had with China with regards to residence, Nigeria, and people after the marriage.
Okay. So after the marriage, and before the marriage, I had already been residing in Canada. And after the marriage, we I got a place. I got a place in. We had plans to eventually relocate and settle in Canada, but we got a place in Lagos as a temporary accommodation, pending the completion of the matrimonial home in Asaba.
Minute, please. There's a lot of distraction. 1 minute, please hold on.
Yeah, yeah.
Meeting. So it's destruction from the house. Just listen to well, I've done it. Just relax. Condition have steps. It's a better thing. It's a 2022. Result for 2 years. That's a thought.
Right. Before the marriage, I resided in Canada. We had plans to relocate and settle in Canada. Please take it from there.
Yes, but however, due to business commitments that required my physical presence in Nigeria, I purchased a home in Asaba.
Right.
The accommodation in Lagos was a temporary arrangement.
Right.
Pending when the home in Asaba would be ready.
Yes.
That's it.
Okay, so when the home in Asaba became ready, what happened? Did you and the petitioner relocate to Asaba?
Well, the petitioner was not willing to relocate to Asaba. She insisted on remaining in Lagos, even though she had a remote job that allowed her to work from anywhere.
Please tell the court, while you were still in Lagos, residing with the petitioner, tell the court if her job was partly was hybrid, if she was going to the office some days and staying at home, some working from home.
I want to step into the box to give evidence for this witness.
And obviously, and the first question, you said the job is remote. Please tell the court if it's completely remote. If her job was completely remote, I mean, all days at working from home.
Thank you. Yes, the petitioner was working remotely as a technical support engineer.
All right.
This is a role that that gave her the flexibility to work from just about anywhere.
Please tell the court what happened in March 2022 between you and the petitioner is leading to complete separation.
Okay. So on that fateful day in March 2022, while I was away in Canada, I received a call from the petitioner informing me of her intention to go on a date with her boss. And this call came into me around 5 p.m. Nigerian time. As her husband, I found it really and highly, and I immediately expressed my disapproval, and I made it clear.
Take it
Okay.
slowly. Yeah,
All right.
fast.
Okay. Sorry.
1 minute, please. Yes.
So I found it highly inappropriate and I expressed my disapproval. I made it clear that I wasn't comfortable with the idea and I opposed to it right away. Despite my objection, um, the petitioner turned over phone and proceeded to the dates. Um, I later got a call from my security guard that the petitioner returned home that day at approximately 11:45 p.m.
What was your reaction to that development? The fact that she went for the meeting?
Petitioner returned. At what time did you say?
I was briefed that she returned home at approximately 11:45 p.m. that night.
Respondent, are you the only one in the room?
Yes.
Where you are?
Oh, sorry.
Can you please do a 360 on with your camera?
Sure.
Okay, that's fine. That's fine. Please do not read, just give evidence, okay? Right.
Yes, my lord.
Yes.
Oh, what was your reaction when you discovered she went on dates and came back at the time you mentioned?
My reaction was that of a deep emotional pain and confusion. As a husband, I just couldn't understand why the petitioner thought it was appropriate to go on a date with her boss while we were still married.
Right.
Tell the call what happened after that.
So shortly after that, I received a call from my security personnel informing me that the petitioner has packed all her belongings and left our home without any sort of notice or explanation.
Right.
What did you do? What effort did you make to connect with her after?
I made multiple contacts, calls, messages. Trainer returned and responded to.
The petitioner.
Right. Right.
Were you able to eventually find out the whereabouts of the petitioner and where was it?
So I finally heard from third parties that because the incident happened in March 2022, and in July 2022, I heard from a third party in her circle that she has relocated to the Netherlands.
Right.
Did the petitioner seek your consent, inform you before relocating to Canada, to the Netherlands?
Nope, my consent wasn't. I wasn't asked for consent or anything. I wasn't contacted.
You were not contacted as her husband?
I was not.
After that separation, did you make any effort as a resolution to resolve the issue between you and the petitioner?
Well, I I sent messages, calls, wasn't responded to. Um, I did my best to try to, get us to talk to see if we could resolve what was going on, but there was no response.
Right.
Did the petitioner or anyone from the petitioner reach out to you or your family to resolve the issues in the marriage?
Nobody. No one reached out to me or my family.
Right.
The petitioner is asking for the dissolution of the marriage. What is your position on that?
I have no objection to the dissolution of this marriage.
Right.
Why have you decided to file an answer and give evidence since you are not objecting to dissolution of the marriage?
I decided to file an answer to present the true facts of what happened and to correct the misrepresentation in her petition and to further protect my integrity.
Right.
Final question for you. Fortune, yes. What else do you have to say to the court on this matter?
Well, I want the court to consider that I made an effort to build a stable home and to build a stable relationship. I invested in a matrimonial home in Asaba, and I also made plans for us to eventually relocate and settle in Canada. Despite this effort, the petitioner abandoned the marriage without discussion explanation or at least a room to resolution. The petitioner's conduct of leaving without notice, refusing communication, and maintaining a questionable relationship with her boss was not only unexpected, but also very hurtful. I believe the court should be aware of these events, not to assign blame, but to understand the emotional and practical um, and the emotional and practical impact her actions had on me and the marriage. My aim is to present the fact as it happens and to seek fairness in how this matter is considered. Thank you.
Right.
How will the case for the respondent?
Cross-examination.
Mr. Obiose, good afternoon.
Good afternoon.
I have a few questions for you. Uh, can you tell this honorable court how available were you as an husband in the marriage with the petitioner?
I do not remember.
What?
I didn't get the response.
I mean, it's been quite. I do not remember. To the best of my knowledge, I made an effort to build a stable home and relationship.
Right. Next question.
During the course of the marriage with the petitioner, was there any case of infidelity with the petitioner? Did you catch out with any man before in an uncompromising situation before?
One
All
minute,
through
please.
the course.
1 minute, please. JL,
Yes,
please ensure that everyone that is online has the video.
Yes. Benedicta, please, can you hear me? Can you turn on your video, please?
Right. What is the question?
I said, but respect, can you hear me, Mr. Biazi?
Sorry, can you repeat the question? I can hear you clearly. Absolutely.
During the course of the marriage with the petitioner, did you ever find her in an uncompromising situation with the opposite sex?
I don't remember the details from a few years ago.
Right.
Can you tell this honorable court the position of the petitioner at a place of work?
Like I mentioned earlier, the petitioner worked in the capacity of a technical support engineer. That role was, you know, it was a remote job, like, which means she could work anywhere. So the best of my knowledge, she was a technical support engineer, and she had a role that gave her the flexibility to work from just about any location.
Right.
The incidents of March 2022 that you recapped before this honorable court. Before that particular incident, was there any issue between you and the petitioner as regards our position in our place of work? Were you at any time not comfortable with the petitioner in our position at our place of work before that day?
To be honest, I really cannot remember events from that time.
Right.
You will agree with me, Mr. Obiazi, that certainly there were issues during the marriage. But was there any moment in time that you asked the petitioner to leave the matrimonial home?
Like I mentioned during my evidence, I was only called and informed by my security guard that the petitioner has moved her belongings from our home. That's all I know.
Right.
You are telling this court you never for once asked her to leave your house for once.
I was called by the security that she has moved my belongings out of our home. That's all I know. That's the last time I heard from her.
Right.
After the incidents of March 2022, did you make any attempts to reach the petitioner or her family members?
Like I mentioned earlier, I made several attempts to reach the petitioner, and there was no response from my end.
Yes.
Mr. Obiazi, sorry for dragging you back a bit. It is customary when you marry someone, you went to her parents, you met her family members. Are you saying that all through the time you had issues with the petitioner, you could not reach just one of the family members of the petitioner?
Like I said, I made an attempt to reach the petitioner. I just don't remember how, but I did make an attempt to reach the petitioner, and there was no response from my end.
Right.
My lord, that will be all for the witness.
Right. Any re-examination?
No re-examination, my lord.
Right.
My lord, we seek the notice of the court. If you can address the court, my lord, today, my lord.
Okay, proceed briefly.
I'm grateful, my lord. My lord, the petitioner by
Proceed.
the petition dated the petition dated 17th December 2024.
Yes.
Seeks the following orders from the court, my lord.
Please do not read out. Just address the court briefly as to why you want the petition granted. Do not read out the claim.
At once, my lord, the petitioner's grant for divorce, my lord, can be is in compliance with section 15 2
Tell the
E.
petition is dated
17th December 2024.
Right. Yes.
The petitioner is asking the Honorable Court to resolve the marriage between her and the respondent on the ground that the marriage has broken down irretrievably. And
Yes.
partners have lived apart for a period of 2 years before the presentation of this petition, my lord.
Right.
And the respondent does not object to the grants of sin, my lord. The petitioner, during the course of trial, my lord, tendered a certified true copy of the wedding certificate dated 19th of December 2020, my lord.
I'm not asking you to summarize the evidence. I'm asking you to address the court on what you are relying on. Have I not admitted? Is the marriage certificate in contention?
I'm just trying to lay foundation, my lord, but as purposes, my lord,
I think you should be concerned about proving that you are entitled to dissolution.
stops, my lord. My lord, in the case of Ibrahim versus Ibrahim, in Ibrahim versus Ibrahim 2016, LPELR 7670, the Court of Appeal held that the conduct of the respondent that a petitioner will not be reliably expected to put up with must be grave and weighty in nature.
Are you gone now to conduct? You have told me, what did you tell me you are relying on? What section of the law did you just mention that you are relying on?
I know section 15.
Ibrahim. Section 15 what?
Yeah, 15. I apologize, my lord. I apologize, my lord. That was the mix-up, my lord. I apologize, my lord. I apologize, my lord. My lord, the case of Abiodun versus Abiodun.
Before you go to Abiodun, why are you citing these cases?
My lord, I'm citing the case on the strength that the parties have lived apart for 2 years, my lord.
That is a cite from the case.
2 years from today, you haven't even said anything about that, and you're busy citing cases.
I apologize, my lord. I apologize, my lord. My lord, the petitioner has given evidence before his honorable court, my lord.
Yes.
And the respondent, by its answer before his honorable court, is not contending against the petition of the petitioner.
And even if the parties both desire divorce, you must still prove, because divorce cases are sui generis. So you can't just. So you are jumping from one point to the other without making any specific point and convincing the court that you are entitled to anything. You have gone from living apart for 2 years. You have skipped over to unreasonable conduct. You have now gone back to what was the last point you made now?
Intolerable differences, my lord. But I was just trying to summarize before the court. That was the reason for the mix up, my lord. I was trying to summarize the whole case, my lord. I apologize for that, my lord. I'll be more fluent man and eloquent now, my lord. Right. I was trying to summarize the thing. Yes, my lord. My lord, the grant being relied on by the petitioner, like I said earlier, where the fact that parties have lived apart for 2 years and the respondent does not intend to object against the grant, my lord, of petition. My lord, the second grant.
What proof do you have for that? You have not been able to prove that the parties have lived apart. That's what I'm saying.
My lord, the petitioner has come to the report that they've been living apart since
you haven't
March
said anything like that in your address.
I apologize, my lord. I apologize, my lord.
Yes.
My lord, the petitioner's case before the Supreme Court was that parties have lived apart since March 2022 to date. And that there's been no form of communication.
Petitioner's case is that
parties have lived apart, my lord, since March 2022.
Yes.
And that there has not been any form of communication between
parties. March 2022.
Have
you council? You please get your thoughts together. Parties have lived apart since March 2022. Does that make you entitled to judgment? Is there no specific or definite time that the parties must have lived apart before you can come under 15(2)(e)?
I said that earlier, my lord, that parties have lived apart for a period of more than 2 years, my lord, before the presentation
you said
of this petition,
from March 2020. Is that the law?
No, but that's not the law, my lord. What I'm saying, my lord, is that parties have lived apart since March 2022 before the presentation of this petition in December 2024, my lord.
Right.
And same fact, my lord, was corroborated.
Right.
Same fact was corroborated by the respondent during the course of trial, my lord.
Right.
My lord, the petitioner cited various character flaws of the respondent that led to their living apart, my lord. My lord, the Court of Appeal, in the case of Akilolu versus Akilolu,
Yes.
2019, LPENR
Yes.
47416.
Yes.
I said that, my lord, that the court sees of the petition for a decree of dissolution of marriage shall adjudge the marriage to have broken down irretrievably if the petitioner can prove just one, my lord, just one
Yes.
or more of the conditions stated in section 15(2) of the Matrimonial Causes Act.
Right.
And the petitioner hearing is relying on the provision of section 15(2)(e) of the Matrimonial Causes Act, and on the fact that parties have since March 2022 till the filing of this petition lived apart, my lord. My lord, it is strike law.
Right.
My lord, it is strike law that facts already admitted, no need no further proof, my lord. The respondent has admitted
Yes.
to parties living apart for a period of more than 2 years before the presentation of this petition.
Yes.
I graciously refer, my lord, to the case of DIN. DIN versus African Newspapers of Nigeria Limited.
Versus
African Newspapers of Nigeria Limited.
right.
1990. LPELR
Yes.
947
Yes.
where the Supreme Court held.
What?
Where the Supreme Court, my lord, held.
I didn't hear the last one. 947.
947, my lord. 947.
And what does this have to do with your point, Leonard Counsel?
My lord, the Supreme Court says that where both parties
Yes.
have agreed on a factual issue,
Right.
no further proof of such fact
Right.
was necessary. That it seems to be an issue between them, my lord.
Right. And you feel that
My lord,
in matrimonial cases, what is the standard of
no,
proof in matrimonial cases?
my lord, that particular law is not on matrimonial matters, my lord. It's to the effect that
Oh, that is
it's
relevant because matrimonial cases are sui generis. So please let's stick to the relevant laws that will assist the court.
as the purpose, my lord. My lord, our point before this report is that the facts stated by the petitioner as regards the separation of parties since 20 is not contested.
Right.
And we urge the court to hold so, my lord.
Okay.
My lord. My lord, the petitioner also is relying on the grant of section 15(2)(d). No, Abrogation, my lord.
Is that
Section
in
15 to C, my lord. 15 to C.
right?
That says the marriage, the respondent has behaved in such a way
Right.
that the petitioner cannot reasonably be expected to live with.
Right.
My lord, the petitioner led evidence to this fact during the course of trial. As to how the respondent treated her through the course of marriage. My lord, without going further ado, my lord, we shall be asking this honorable court, my lord, to grant the petition of the petitioner, my lord.
You said the petitioner led evidence as to 52C.
As to the behavior, the intolerant behavior of the respondent, my lord, during the course of marriage. You submit, my lord,
Right.
that the petitioner has been able to prove at least one of the requirements stated in section 15.2 of the National Police Act.
Right.
And we call this honorable court to grant the petition of the petitioner.
Right.
I'm grateful, my lord.
Can I hear the respondent's counsel?
Yes, but we're ready to respond.
Briefly, please.
Yes, well, we'll not belabor the court. We'll go straight to the issues and address them. The first issue being that whether the petitioner has presented material facts before the honorable court as to be entitled to the relief sought for the solution of marriage.
Right.
The law, section 15, sub 1 of the Matrimonial Causes Act, section 15, sub 1 of the Matrimonial Causes Act, empowers the lordship to dissolve a marriage that has broken down irretrievably.
Right.
However, a party seeking dissolution of marriage, the petitioner seeking dissolution of marriage must be able to switch the case on any of the grounds listed in subsection 2 of the Matrimonial Causes Act.
I didn't quite hear you. The last statement.
Okay. However, the petitioner must be able to situate its case on any of the grounds listed in subsection 2 of section 15 of the Matrimonial Causes Act.
Right.
It is the case of the petitioner that the parties are believed apart for 2 years, immediately preceding presentation of the petition, which is the evidence before the court confirms that the cohabitation ceased in March 2022. Cohabitation ceased in March 2022. whereas the petition was filed on the 17th of December 2024.
Right.
That satisfied the first leg of paragraph E of subsection 2 of section 15. The first leg is satisfied because March 2022 to 17 December 2024 is up to 2 years.
Right.
The second leg of that ground is that the respondent does not object to the petition for dissolution of marriage.
Yes.
Well, the answer filed by the respondent, as well as a testimony on own for your God.
Right.
The respondent confirms two things. It confirms that cohabitation in March 2022.
Yes.
He also confirmed that he is not objecting to the petition for dissolution of marriage.
Yes.
It is a submission, therefore, that the provision of section 15, subsection 2E of the Matrimonial Causes Act have been satisfied.
Right.
The lordship is authorized by subsection 1 to grant the prayer for dissolution of marriage. Now,
Right.
I'll proceed to the second issue raised by my learned friend, and it's a submission, sir, that reliance on section 15 2C is an afterthought. Respectfully, sir. There's every submission on section 15 2C is an afterthought.
Is
I'll
what?
explain it. An afterthought.
Right. Yes.
First, if you try that facts not pleaded, go to no issue. There's nowhere in the entire petition. There's nowhere in the entire petition where reference is made to intolerable conduct by the respondent, which the petitioner cannot be expected to deal with.
How about other sorts that the respondent has behaved that is on the 10G of the pleadings?
Yeah, Lord, this is that is other source, but in the body of the petition itself, fact, there's a provision for facts.
That's C. How about 8C?
I see here. All right. Nonetheless, there are submission that no report of hidden evidence by the petitioner.
Sorry?
It's a submission that why giving evidence, why give you evidence, but why the petitioner gave evidence before your lawsuit?
Yes.
No material, particular
Right.
were presented before your lawsuit.
Right.
Substantiate the claim of intolerable conduct.
Right.
As to situate the matter within the provision of section 15 sub 2c of the Matrimonial Justice Act.
Right.
With all your lordship, countenance, that ground has not been applicable to this petition.
Right.
And grant the petition only on the basis of 15(2)(a).
Right.
Well, this is
registrar date for judgment.
10th of September, my lord. September 10th.
just a minute. That's September 28th.
10/9 then for judgment. Judgment will be in open court, not virtual, unless you want another session virtually. I advise you not to. 10/9 for judgment.
Petitioner might want to pay for sale.
My lord, we are not doing that. I'm bringing my lords.
I didn't even ask if they had complied. Mrs. Adeditu, did the Respondents' Council comply with the other 32 in terms of?
Yes, my lord. Yes,
My lord.
Okay. 10/9/25 for judgment. Mrs.
Okay.
Adeditu, please end the
Yes.
session.
All right, my lord. Thank you, my lord.
Right.
All right, thank you, Mr. Fortune. Thank you, Mr. Dewey. Thank you, Benedicta. We've come to the end of this virtual session. Thank you.